How long does it take to get a patent? The answer surprises most people, so stick around, and this video is going to give you all the answers to the questions about the time it takes to get an issued patent and the variability of it. So if you're new here, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit with Marcus Lemonis. So this channel is all about giving you the insider tips that I use with my clients every day, whether they be Fortune 100 companies, startups, or even Shark Tank businesses to help them protect their ideas and inventions. So subscribe to the channel if you want more on startups and patents, and click the little bell icon to get notified when new videos come out. All right, let's get right into it. So the short answer is it takes a long time, and specifically, it can take years to get an issued patent from when you first file your initial patent application. And I'm gonna share with you in this video sort of the process of how long it takes and why it takes so long, but also why it's not that big of a deal that it takes so long, and if anything, it's actually a good thing. So stick around to the end where I get into those secrets about the length of time not necessarily being a bad thing. So let's first start off with the patent process and generally what that is and where the time comes into it. So first let's start off with the two ways to start the patent process. One is to file what is called a non-provisional patent application, and that's the application that actually matures into an issued patent. You file that application at the United States Patent and Trademark Office, and it waits in line for anywhere from 1 to 3 years. And why is that? Well, it's just because it's the federal government. They have a huge backlog of patent applications that they need to go through. And so before examination even begins, it can be 1 to 3 years, depending on the type of technology. When patent applications are filed, they're assigned to what's called an art unit. And the different art units, they will do examination on different types of technology. Some of the art units are really backed up, like things like computers. You know, those things tend to take a lot longer. They can be sometimes in more like the 3-year range, whereas other technology areas aren't as busy, and maybe examination only begins after a year, maybe even less, or definitely less than the 3-year mark. So 1 to 3 years goes by after you file the non-provisional patent application, and then the examination process begins. And what happens there is the patent examiner is going to do a prior art search to determine whether the invention as claimed is new and non-obvious over the prior art. And prior art can really be any sort of technology disclosure. Most of the time, this is going to be issued patents or published patent applications, but really it can be any sort of technology disclosure. It could be websites, blog posts, videos, actual products in a catalog, scientific journal papers, really any technology disclosure could be used as prior art as long as it was in existence before you filed your patent application. So the patent examiner does this prior art search and then will create rejections against the application and mail them to you in what's called an office action. And then you have, typically it's going to be 3 months to respond to this office action. It can be up to 6 months to respond. And then once you respond, it can take a long time before the patent examiner then will review the office action, maybe do another prior art search, and then typically will come back with more rejections after doing another prior art search. So from when examination begins to filing your first office action, you can do that quickly, but typically it's going to be in the range of months before you actually file that response. And then it can be months or sometimes years before the examiner will actually get back to you after you respond to an office action. So this back and forth can go really indefinitely, as long as you're willing to fight the rejections and pay money and things like that. It can go on for years upon years upon years. But typically, you're going to go back and forth with the examiner, I would say on average 2 to 3 times. That's pretty typical. Sometimes you get lucky and the application is allowed immediately. That's pretty rare. But sometimes on the other side is you have to battle out with the examiner, and you can go back and forth 6, 7, 8 times, which takes a long time. So when the examination process begins, it can be years upon years sometimes before you start examination to when you convince the examiner what you have is new and non-obvious. Depends on how many times it goes back and forth, and sometimes there's delay at the patent office. You get an examiner who maybe goes on vacation or loses your file or just is really backed up, and it takes a long time for them to get to your stuff. I've had patent applications be in examination for close to 10 years. But a lot of times it's not that long, but I would say on average, it's going to be a few years. It's going to be at least a couple years, sometimes 3 years, depending on how much you have to go back and forth with the examiner. So that was the first way to start the patent process, which is, again, what's called the non-provisional patent application. But for most startups, and what I think is a great way to start the patent process is actually what is called a provisional patent application. So the provisional patent application process, you file a provisional, it lasts for 1 year, and then the provisional patent application expires after that year. That term can't be extended, and you have to file the non-provisional before the provisional expires. So doing the provisional, which again is what I recommend typically for any startup and most businesses, that's going to add another year to the patent process. And probably what you're asking yourself, and what most people think is, well, that's crazy. I want to get a patent as soon as possible. That's what's most important. I need to have an issued patent. And some people think that, well, before I even start selling my product, or before I start talking to investors or doing anything with my business, I need to have an issued patent. And that is one of the biggest mistakes that startups make, is thinking that I need to have an issued patent in hand. That is absolutely untrue. And what I'll tell you is some of my most successful clients, and in fact, the most successful clients that I have, they are able to get substantial traction with their business, whether that be sometimes selling the company or licensing the idea, or getting huge investment and have a product out that's already selling, making tons of money, well before they even get into the examination phase, and then well before they even have an issued patent. And that's confusing to people. They think, well, I need to actually have the patent in hand. But the reality is that you don't actually need to have an issued patent. And it actually is a positive thing to allow the patent examination process to go a reasonable amount of time, but it's not necessarily a bad thing if it takes a long time. It certainly can look bad from an optics perspective if you have a lot of rejections. And a good example was when I was featured on The Profit, CNBC's hit show with Marcus Lemonis. And if you watch that episode with Coco Vinny, one of the big issues that Marcus had with Coco Vinny's patent portfolio was that he'd been rejected 8 times in his patent application. The reality is that's not necessarily uncommon, and I think it was a lot of the strategy that his patent attorney was using, really just going slow and not really making a lot of progress per office action response. But at the same time, investors look at something and they say, well, there's been a lot of rejections, that's a bad thing. And so in a lot of ways, you want to get through the patent examination process as soon as possible, but it's mostly from an optics standpoint. Again, you don't need to have the issued patent in hand. So one of the things that people think is, well, I want to be able to enforce this patent against people. I want to be able to stop people from doing things. I don't have any protection until I have the issued patent. But really, it's absurdly expensive to assert a patent. It is really expensive. It's going to be in the tens, if not hundreds of thousands, if not millions of dollars to actually do a patent lawsuit. And a lot of times it doesn't really make sense from a damages standpoint. And people think, well, I want to stop people immediately. Well, in terms of damages, it's better to let damages accrue, okay? Because once there's actually damages, then it makes sense to actually sue somebody. You can actually get some money for it. Otherwise, you're going to spend tons of money, and the court says, "Well, okay, sure, you've convinced me that there's infringement here, but your damages are $10,000." And then your attorney is going to hand you a bill for $500,000. So it doesn't make a lot of sense. And another thing that people don't realize is there's so much benefit just to having a pending patent application. So people see patent pending on something, and even if it's published and they're able to look up the application, by default things are held in secret for 18 months from when they're actually from the original filing date. But even once it's published, people don't know what's actually protected. A lot of people think everything in the drawings and everything in the specification, everything in the description is actually protected, when that's not really the case. It's actually what's in the claims, usually a big subset of that, or a small subset of what's actually in the description and drawings. And it just sort of creates fear, uncertainty, and doubt in the marketplace. So there's a lot of deterrent even with a pending patent application. And that's something that really kind of confuses people. So it's like, well, well, I need to have this issued patent so I can enforce it. But having an issued patent isn't essential. Another thing that people think is, well, I need to have an issued patent. I need to get this as soon as possible because, investors won't work with me unless I have an issued patent. Again, completely untrue. And I would say the vast majority of my clients, they're the ones who are successful. They're the ones who actually get investors well before examination begins or before the patent actually issues. Investors don't need to see issued patents, or at least good investors don't. Sure, there's going to be some investors who say, well, I want to see the issued patent, but a lot of times that's kind of a way that they're blowing you off. There's like, well, let's talk about it in years and let's see if this even happens. It means that they don't really believe in your idea. What's more important is the collaboration and the business. Patents are a means to an end, not an end in of itself. It's an important thing to have eventually, but not something you need to have in order to attract investors, and especially to attract the right investors. So you shouldn't be concerned if the patent application process is going to take years. It's not necessarily a bad thing. Just make sure that you set it up with your patent attorney so it's not going to drag on too long. And that's why with my clients, I try to set up so we're going to get to issuance within 2 to 3 office actions. That's typically the plan, and ideally 1 to 2. There are some ways you can expedite things, but sometimes, you get a bad examiner and they don't do a very good job and the rejections are horrible and you really just have to tell them like, no, that's wrong. And then they come back with even worse rejection. You have to say, no, like you're misunderstanding this, you don't get it, right? And it can take a long time, but a lot of times you can set up the negotiation with the examiner so that you can get an application through within 1 to 3 office actions. I mean, obviously there's got to be something patentable there, but that's usually doable. And that's how I like to set things up. So there are ways to expedite the patent process. You can file what's called an accelerated exam application by paying a bunch of filing fees and doing a prior art search and a bunch of analysis that you submit with the patent application. And supposedly examination is supposed to start within a number of months or within a year or so, and then examination is supposed to go a lot faster as well. But a lot of times that's really not worth the extra price of the filing fees and all the work that you have to do. It ends up being really expensive. And again, having an issued patent really isn't the ultimate goal. You can do a lot with your business, and if anything, you can save a lot of money by delaying issuance of your patent application. So having a pending application is actually a good thing. So as far as the time it takes to get an issued patent, I would say on average it's going to be 2 years. Could be a little bit less in certain types of technology, but it could be a lot more in certain types of technology, and depending on the examiner you get, it's really variable. And this changes depending on the backlog at the USPTO. It's started to go down. I mean, I would say, I typically tell people it's 1 to 3 years, but these days I don't see quite as many 3-year applications that are pending before examination even begins. A lot of times examination will begin, within 1 to 2 years, but every once in a while we're still seeing, 3-year applications before examination begins. So that's kind of how long it takes to get an issued patent. Let me know what you think down in the comments. Do you have any questions? Do you think this is absurd? Do you disagree that it's a good thing to actually wait? And if you got value out of this video, please give it a thumbs up. We'd appreciate it. The YouTube algorithm loves it when there's interaction with the content. And if you want more insider content and tips on patents and startups, be sure to hit the subscribe button and click that little bell icon so you get notifications when new videos comes out. Thanks again for watching. Really appreciate it. And we'll see you again in the next video.